Mr Gray.
I'm grateful. We've added two authorities. I'm not going to take you to them. Can I just mention that they're there in the additional materials bundle? Still on this theme as to the legitimate purposes of committal application. We've added a case called JSC BTA Bank against Solodchenko, which is in tab 7 of the additional materials bundle. And that you will see sidelined paragraphs 45 to 48. I don't ask you to go to it and read it now because I'm going to have to pick up the pace slightly to get through what I need to get through. But that illustrates the legitimacy of bringing committal applications in relation to past and irremediable breaches. So one of the sticks with which we were beaten was that my client waited until after he was paid for the shares in Navio before bringing this committal, and that therefore the committal application was not being brought in order to enforce any court order, because the moment for compliance had passed. And at our submission, that is not evidence of abuse, and it is not a fair point to be taken, because, as I say, one of the legitimate purposes of committal is to punish for past breaches. And the same point is made in relation to that by our other new authority, EIM and Stature, EIM and Stature, which again I don't ask you to go to now, but it's in tab 8 of the additional materials bundle. And at paragraphs 105 and 111, you will see those passages sidelined. Again, making clear that the question whether or not steps have been taken to make good a past breach does not mean that there hasn't been a contempt. In that case, somebody had diverted assets, caught, so to speak, and most of them were restored. And the court says twice the fact that most of the money had been returned doesn't mean that there wasn't a breach in the first place and a contempt. Just moving on then, so that's the sort of the introductory point on legitimate purpose. The next point I just wanted to touch on in place in the argument is a point I've really already made, and I have little to add to, which is that the judge in our submission was wrong in principle to proceed to determine the question of abuse without applying his mind at all to the question of whether or not there was a serious breach of the undertakings. In our submission, it is an extremely short point, but it is not one that I think I can really elaborate on. In order to decide whether or not an application is abusive, the court should take into account the question of whether or not the application is itself well-founded. If it is well-founded, the court then has to consider why, if at all, an otherwise well-founded application to commit for contempt should be rendered in an abusive application simply because, for example, the applicant doesn't like the respondent. So that in our submission is an important point on the sequencing with which the judge approached the matter. And as I say, it's not just a question of case handling in terms of what order to deal with the issues. It's a question of actual principle as to what are the relevant considerations to take into account in deciding on abuse. And the last preliminary point, before I get to the actual grounds of appeal, the last preliminary point we just wanted to draw, and this is a thread that runs through a lot of what we say, is that in our submission there is a clear principled distinction between what are generally called civil contempts, that is, violations of a court or of an injunction or an undertaking not to do something, and what are generally called criminal contempts, which involve interfering with the administration of justice. The distinction operates at the procedural level because criminal contempts require the court's prior permission to bring the application. And one can see that in part, as you may know, Part 81 has been in a state of transition. Yeah. But the relevant version for our purposes is in the authorities bundle, bundle 2 tab 34.
don't think the changes are material for
No,
us,
they're not. They're not. And the same distinction is still drawn in the new rules. But one can just see from the sort of contents page of Part 81 that Roman heading 2 after 81.3 is committal for breach of a judgment or order or undertaking to do or abstain from doing an act. And then after 81.11, Roman 3, committal for interference with the due administration of justice. They are procedurally dealt with differently, and the critical difference, if we go to page 867, in Rule 81.12, this section regulates committal applications in relation to interference with the due administration of justice. Paragraph 3, a committal application under this section may not be made without the permission of the court. And it is at the stage where the court is deciding whether or not to grant permission that the question of the public interest in the proceedings being brought comes into play. That we have already seen mentioned in the Sector Guard case, where you may recall when I emphasised in reading that it was in the context of applications for permission that the label of public interest proceedings was used. And it becomes even clearer in the case of KJM Superbikes, which is in the first, we put away the second authorities bundle, get the first authorities bundle out, tab 10. While you're getting at it, just mention the background. So this was an action by Honda, basically, for infringement of its trademark involving parallel imports. The defendant who was being sued by Honda survived just an application for summary judgment. And after that, it emerged that the evidence that Honda had relied on from one of its directors was very substantially untrue. So the defendant then sought permission to bring committal proceedings against that director. And if we could just pick it up at page 120, this is the Court of Appeal decision, the judge below having refused permission at paragraph 7 on page 120, Lord Justice Moore-Bick says the judge recognised that KJM's desire to take proceedings against Mr Hinton was motivated largely by anger. He didn't find that surprising, since it had been successful at the trial after having only narrowly avoided summary judgment being entered against it at a time when it did not have much, if any, material with which to challenge Mr Hinton's lies. However, he rightly identified the question he had to decide as being whether it was in the public interest for proceedings to be pursued against him for contempt. Excuse me. And then that goes on, just to stick to the bare minimum necessary. If we can look at page 122, right at the top of the page, first line, proceedings for contempt of the kind contemplated in this case, albeit civil rather than criminal, are public in nature, and by committing an act of a kind which is liable to interfere with the course of justice.
Sorry, I don't understand that. Proceedings for contempt
of the kind contemplated in this case.
So this was a civil case?
This is a civil case. Well, it is a case in respect, no, this is what falls within what is regarded as criminal, because it's one of the ones for which permission is required. That's the difference. Because it's interfering with the administration of justice by giving false evidence.
Civil proceedings, but criminal
Civil
in nature.
proceedings, but a criminal contempt. Proceedings for contempt of the kind contemplated in this case, albeit civil rather than criminal, civil proceedings, yes, are public in nature, and by committing an act of a kind which is liable to interfere with the course of justice, the witness exposes himself to the risk of punishment by the court. When the court gives a person permission to pursue proceedings for contempt against a witness who is alleged to have told lies in a witness note, it allows that person to act in a public rather than a private role. So it is the court deciding whether or not it is in the public interest that what is known, albeit in civil proceedings, as a criminal contempt, should be allowed to be brought, that brings into play this concept of clothing the applicant with a public rather than a private role. And that is a distinctive characteristic of what are called criminal contempts, albeit in civil proceedings. They are the contempts in respect of which permission is required, which is not this case, my case. And we go over the page, para 16. Whenever the court is asked by a private litigant for permission to bring proceedings for contempt based on false statements allegedly made in a witness statement, it should remind itself that the proceedings are public in nature. So that then, as I say, feeds into the observations that we saw in the sector guard case, which again, deliberately and importantly, talk about the public law, the public interest and the public nature of the role of the applicant in contempt proceedings where permission is required. But what is called a civil contempt, which is what this case is, namely just not obeying a court order, no permission is required. We don't have to come to the court to get permission and persuade you, or the judge below, that Mr Chernukhin is a suitable person to have conduct of a committal application. And the follow-on from that, we will submit, as you will see, is that we say the judge took a wrong turn when he said that the applicant, Mr Chernukhin in this case, and Navigator, were assuming the role of a disinterested public prosecutor, and that they got it completely wrong by bringing the claim in what he considers to be an aggressive adversarial fashion.
Could we just step back a second? Because I fear that I've either misunderstood or you've run two things together.
Right.
Which is civil proceedings, yes, but one is a criminal contempt and one is a civil contempt.
Yep.
Civil contempt being a breach of an order or an undertaking, for example.
Yep.
Criminal being doing something which actually affects the administration of justice.
Yep.
Accordingly, it brings into focus whether there is a public interest in proceeding in that way in relation to committal of in such a matter.
Yes.
Therefore, you have to seek the permission of the court.
Yes.
But if one goes back to paragraph 11 of Lord Justice Morbick's judgment in Superbikes, he then goes on to say that one is looking at the public interest, but he also mentions whether the person is an appropriate person to bring the proceedings.
Yes.
And I think in your submission just a moment ago, you dovetail the two together.
Sorry.
And I'm just concerned to be clear, because it might in this case have an effect, but in Superbikes, perhaps also in some ways resonated with the fact that you showed us the paragraph where it said it can be understood that the other side were angry, that there is an element about whether it's the right person to bring the criminal proceedings.
Yes,
but as I understand that, it's just, is there a public interest, which is a separate question, and then is this person appropriate? But it's not looking at motive even in this situation or not. I'm sorry that was very long-winded, Mr. Gray.
In the case of in a case where the court is deciding in the context of a criminal contempt, where an application is made for permission, when it is deciding whether there is a public interest in the committal application being heard, and when it is deciding whether the applicant is a suitable person to have carriage of that application, the fact that the applicant may be motivated by animosity is capable of being a relevant factor.
That they may not be the appropriate person.
Yes.
Because they may not be the person who could quasi-prosecute.
Exactly so. But the position in relation to civil contempt is different.
Just following that, the judge may decide there is a public interest, but it would be better served by the Attorney General being the person who should consider whether to bring the contempt.
Absolutely. But in relation to a civil contempt, the position, is procedurally different. And it's procedurally different for a reason of principle. And the reason of principle is that in relation to a civil contempt, you are by definition dealing with a situation where the court, in the course of civil litigation, has made an order against one side for the protection of the other. If that order or undertaking has been broken, the person who is meant to be being protected by that order or undertaking necessarily has an interest in the enforcement of that order. He can't be a dispassionate public prosecutor type character. Because if one of the entirely legitimate, indeed perhaps in some senses the principal function of committal, of a civil committal case, is coercion to enforce an order which has been made for the benefit of one of the interested parties in the litigation.
And what the judge said here was, in the particular, he said a couple of times, in the particular circumstances of this case, and by that he was referring, amongst other things, to the fact the award had been paid. So let's say you have to have a private interest if you're in category, and you're the first limb of justification for the contempt application. But we're in the second limb, which is bringing serious misconduct to the attention of the court. And you say there's nevertheless no difference in approach.
We do say there is nevertheless no difference of approach. The judge, in our submission, was drawing support from a line of case law which is dealing with criminal contempts, which is irrelevant. Did not, in our submission, identify any authority to support his approach.
And I can't actually remember, it's my fault. And Ms. where are we in his judgment? Just reminding myself of...
So it's, I think it's paragraph...
I'm so sorry, I know you want to carry on, speed up, but this is important.
I think
It's at the
it's
beginning,
138.
beginning of abuse, isn't it?
Yeah, quasi-prosecution is para 138.
Yes. And where does he get to the...
And he gets...
Here we go, 143.
Yeah, so the cases he cites, I was going to come to them, but I'll mention them now. So in 138, he mentions Maximov, which we'll look at in a moment. He mentions KJM Superbikes, which is a criminal contempt case. And he mentions Supermax and Malhotra, which says literally nothing more than that an application must not be brought for an illegitimate purpose, which in our submission meshes entirely with our analysis of sector guard, which is that it's talking about what is the objective of the objectively viewed. Is there a legitimate purpose? Not subjectively, why does this applicant bring this application? Objectively, is there a legitimate purpose in terms of, is it more than a technical breach? Is it a serious breach that's being brought to the attention of the court? Or is it being brought for coercion?
And was Maximov a criminal contempt?
Maximov, I'll just find my note on that for a moment. No, it wasn't a criminal contempt, but if one looks at it,
Are you going to come to it?
Well, I'll deal with it now since we're sort of on a roll on that one. So it is in volume 1 of the authorities bundle at tab 18. What is said, I don't think you need to get very much to it, because the judge uses the expression legitimate aims. And he does so, well, it may be helpful actually to look quickly. So he does so under 1 tab 18. This was a purely technical contempt because a company and a director were required to give disclosure. The company did, the director didn't give the same disclosure, but the disclosure had been given. So it was a purely technical contempt. And if you go to page 384 of the bundle, you'll see paragraph 21. We get all the stuff from Sector Guard, which I've read to you, which identify what legitimate purpose means. It means either coercing compliance with the court order or bringing to the attention of the court a serious rather than a purely technical breach. And that's what the judge means. Having quoted Sectorguard at length, that's what the judge means in para 22 when he endorses those comments. An increasing amount of the court's time is taken up with contempt applications. Claimants should give careful consideration to proportionality in relation to the bringing and continuance of such proceedings. In appropriate cases, respondents should give consideration to applying to strike out such applications for abuse. The court should be astute to detect when contempt proceedings are not being pursued for legitimate aims. Adverse cost order may follow. His use of legitimate aims there is not a reference to the subjective motivation of the applicant. It is a reference to whether or not one can tick one of the Sectorguard boxes. Is it a purely technical breach, which is what the judge was saying here, or is it a serious breach, or is it being brought to coerce compliance? So in our submission, the judge in our case, when he cites that one line from Mr Justice Hamblin as he was in Maximov, is just taking it entirely out of context and getting from it something that just isn't there. The distinction that Mr Justice Hamblin was drawing was between purely technical breaches. Yes, the director hadn't given disclosure, but it was a purely technical breach because the disclosure had been given in that case. So this was not a case, Maximov was not a case, where a serious breach was being brought before the court. And that is what Mr Justice Hamlin meant when he said the court...
Sorry to interrupt. It's just
No,
you were closing up, and I was just going to say that's clear from paragraph 23, where he says, however, it is a case or in which, meaning this case, his case, in which the pursuit of the proceedings has merely led to the establishment of a technical contempt rather than something of sufficient gravity to justify the imposition of a serious penalty.
I should have taken you to that. Yes,
no, I'm just sorry to have spoken over you. It was just that you were closing off now.
I'm very grateful. So that is quite a lot of what I need to sort of put in place before turning to the actually enumerated 5 heads. And if I could just run through them. So the first one I was going to deal with is it relevant to take into account the subjective motive of the applicant? And the judge clearly did do that in paragraph 157 of his judgment. It was one of the grounds on which he said that the application was abusive because he said that Mr Chernukhin was motivated by a desire to pursue the contempt charge as an act of revenge for Mr Deripaska's twin moves in May 2019, namely the 2019 letter and the private prosecution. You may recall Mr Deripaska brought a private prosecution which the DPP then took over and discontinued against Mr Chernukhin. So the legal issue this raises is it a relevant consideration in deciding whether or not a committal application is an abuse to look at the subjective motives of the applicant? And in our submission, having got the framework in place, the submission can be made very shortly, which is that it's not. The question for the court in deciding whether or not an application to commit is an abuse is to look at the legitimate objectives identified in Sectorguard and decide whether the application to commit pursues those objectives. That is an objective question of what is being brought before the court. It is not a subjective analysis of why an applicant wants to bring that before the court. And
at some stage, you're going to have to address us, I think, on the TBD case, which appears to have endorsed these remarks.
I absolutely will. What I'm just going to do first of all is just to say that the submission that we offer to you in relation to this point is, we would say, based on principle, and we say on authority, and also on practicalities. Those 3 points: principle, authority, practicalities. And I just want to develop those a little bit One of the authorities in the bundle, I'm not going to take you to it, but one of the authorities in the bundle is the case of Masri and Consolidated Contractors, which identifies what are the constituent elements of a contempt of court. If you want to look at it later, it's paragraph 150 of Masri, which is in Authorities Bundle 1 at tab 12. And essentially what you need is that you need a clear and binding court order. You need to identify whether the respondent knew of the order, and you need to identify whether the respondent deliberately did an act which constituted a violation of the terms of the order. That's what a contempt is. None of those turn on what the applicant thinks. So, as a matter of principle, in order to decide whether a contempt of court has been committed, the subjective beliefs, motivations of the applicant are, in our submission, as a matter of principle, entirely irrelevant. As a matter of authority, we have built a lot of the building blocks. I just wanted to refer very briefly to a couple of the cases my learned friend does rely on, and we'll get to the TDM case in a moment. But the ones I think under this heading that he relies on are Integral Petroleum and Petrogat, which is in Authorities Bundle 2 at tab 29.
Can I just understand your submission there? Are you saying that the subjective motivation of the applicant is irrelevant to the question of whether there has been a contempt, or is irrelevant to the question of whether an application is an abuse?
In our submission, the answer to the question is going to be the same, because if there is a serious case of contempt of court rather than a purely technical one, then the reason why an applicant is bringing that to the court is an irrelevance, both to the question whether or not the contempt has been committed, and also to the question of whether or not it's an abuse. Because if it is the case that there is a serious contempt, with the greatest respect, it's difficult to see why the personal animosity of the applicant can alter the legitimacy of bringing that before the court. I'm grateful for being able to clarify that. I'm sorry if I didn't make it clear. Integral Petroleum and Petrogat was a committal application arising out of a contract for the sale of oil, in which an injunction was granted restraining delivery of oil to Iran rather than delivery of the oil to the contracted destination. If we can just look very briefly at paragraph 6, page 655. If we just pick it up at paragraph 39, the judge is here quoting, and this is a judgment of Mr Justice Foxton, recent judgment of Mr Justice Foxton, and the quote at paragraph 39 of the judgment is from Lord Justice Millett in the case of Knox and Darcy, which is picked up on the page before. And what Lord Justice Millett said in that case is, "It is obvious to me that the threat of committal proceedings against Mr Steele and Mr Campion is being used as a lever in order to obtain a favourable settlement of the litigation. That, to my mind, is a gross abuse of the process of the court. Indeed, I observe that in 1983, the obtaining of money in consideration of an agreement to discontinue contempt proceedings has held itself to be a contempt. What was attempted in the present case is not far short of that. It was a plain attempt to obtain a favourable settlement of litigation by threats to bring committal proceedings against the guiding mind behind the plaintiff and their English solicitor." And then if one picks it up again over at paragraph 33 on the next page, in considering the third party's submission that the committal proceedings were an
I'm
abuse
sorry, I've lost you.
I'm so
The
sorry.
following page is paragraph 42.
43. I'm going to
43,
look at
yep.
page 656. Finally, in considering the third party's submission that the committal proceedings were an abuse of process because they were commenced for an improper purpose, he notes the Privy Council decision held the tort of abuse of civil process would only be established if the proceedings were conducted for a predominant purpose other than those for which they were designed, so as to obtain a benefit other than that for which they were designed. And over the page, at paragraph 44, in determining whether the committal was commenced or pursued for the improper purpose of forcing a settlement, I will proceed on the basis that the pursuit of an application to commit will not be such an abuse unless the applicant has a real and substantial purpose to use the threat of committal to force the respondent to settle the claim. While I can see a strong argument in favour of the view that before striking out such an application on the basis that it is an abuse of process, it should be necessary to establish a predominant purpose of the Crawford kind, it's not necessary for me to resolve the issue on this application. So that, in our submission, if one holds that case up against the sector guard test, it was a case where none of the legitimate purposes was being pursued. It was not, the application for committal was not being pursued in order to bring a serious breach of a court order before the court, and it was not being pursued in order to enforce compliance. It was being pursued for a collateral purpose. It is not, therefore, authority for the proposition that where one of the legitimate purposes is being pursued, an otherwise well-founded committal application becomes abusive because the personal motivation of the applicant is driven by animosity. It is simply not authority for the proposition that my learned friend needs. And the other authority that he seeks to rely on is Tinkler and Elliott, which is in the first authorities bundle at tab 19. I won't go to that, but you will see if you look at paragraph 111 in that, so it's authorities bundle, but you may just look at it here. Authorities 1, tab 19. This was some sad and long-running litigation between a former helicopter pilot and his former employer. The relevant point for our purposes is that this was a case, we see from paragraph 24 on page 394, this was a KJM Superbikes case, so to speak, where permission was required to bring the contempt proceedings. And therefore the question of whether or not the applicant was a suitable person to have carriage of public interest proceedings became relevant. And one sees again, as a result of that, if you go over to page 396, paragraph 29, paragraph 29, he says the judge correctly set out the legal framework at 20. He had been referred to Malgar, KJM Superbikes, and another case, the last of which he referred to in his judgment. Those authorities show that in order to give leave, the court must be satisfied in relation to each allegation that strong prima facie case, balancing of proceedings was the bringing of proceedings was in accordance with the public interest, proportionality, and the overriding objective. And the fact that that is all a matter of judgment and discretion is apparent from paragraph 111 at page 418. So our submission is that none of the cases that were identified either by the judge or by my learned friend support the proposition that a committal application which does pursue one of the legitimate objectives identified in sector guard.
Can I just your paragraph 29 too, isn't that just reciting the submissions that were being made by Mr Hollander? Just I mean, it's looking at it starts at paragraph 23. I'm just not clear. Is that not just setting out?
That's correct, I think.
No, I think you. Sorry, I think you lost it.
Mr. Hollander said shouldn't have gone.
Yeah, no.
But you get the same from paragraph 44, Roman numeral 5 on page 399, where
Right.
Yeah,
the judge sets out before permission is given, the court should be satisfied that.
yeah,
Right.
yeah.
Yeah.
No, you're right. I'm sorry. I was led into error by my learned friend who cited that paragraph as the one he relied on. But I'm prompted by my learned junior that was why we had gone to that. But I'm grateful. We get the same, I think, in the body of the judgment. But your lordship's quite right. So, as a matter of authority, as I say, we say there is no support for the proposition that an otherwise well-founded committal application becomes an abuse because the applicant doesn't like the respondent. And the final question, the final topic, I said there was a point of principle, point of authority, point of practicalities. On practicalities, what is the court meant to do if this is good authority? What is the court meant to do in terms of working out, well, how much does the applicant have to dislike the respondent for having broken an injunction granted in his favour before the application becomes an abuse? What test is actually being applied? Of course, a litigant in whose favour an injunction has been granted is going to dislike the other side if the other side breaks that injunction. So what level of animosity becomes relevant in this context? In our submission, it simply raises an impossible issue, and one which the court shouldn't be getting itself involved in. So that's a quick count through the first ground of appeal on abuse. We say subjective motive irrelevant. Very closely related is the second ground of appeal, which again we've already largely anticipated, which is that the judge was wrong in deciding as he did. It's paragraphs 143, 145 of the judgment. The judge is wrong, we say, in reaching the conclusion that in a civil contempt case such as this, the applicant has to perform the role of an entirely dispassionate public prosecutor. The points are that essentially, for the reasons we've already explored, civil contempts inevitably involve a situation in which the applicant is going to have a personal interest in the outcome. There isn't in our submission any support for the proposition that in civil contempt the applicant has to perform the role of a dispassionate prosecutor. The one case that I think that the judge lighted upon, or possibly my learned friend, is one of the numerous Abliazov decisions. If we could just look at it briefly to see what it did and what it didn't say. It's the one at Authorities Bundle 1, tab 15. And I think we can just go straight to page 282. And you'll see that the argument that is identified in paragraph 14 at the bottom of the page, it was put to Mr Hardman, who's the solicitor representing the bank against the defendant and was bringing the committal application. It was put to Mr Hardman in cross-examination that the purpose of this application was not to police the worldwide freezing order, but to knock out Mr Abliazov, by which I understood counsel to allege that the bank wished to prevent him from defending the claims which had been brought against him. And then he says he accepts Mr Hardman's evidence that he, as the solicitor at Hogan Lovells with primary responsibility for the litigation, has brought this application for the purpose of bringing further pressure to bear on Mr Abliazov to comply with the worldwide freezing order. So the purpose was the legitimate sector guard coercion. The relevant passage, I think, for our purposes is paragraph 15 over the page, and it is, in our submission, important to see what it does and what it doesn't decide. It is further submitted that the bank did not play the role of a dispassionate prosecutor on this quasi-criminal matter, but presented its case by the use of evidence and submissions which were at times prejudicial, tended towards rhetoric and exaggeration, and strayed beyond the scope of the issues in dispute. So that's the submission on one side. Mr Smith, QC, counsel for the bank, pointed out that the bank did have its own legitimate private interest to pursue, and was therefore not wholly to be equated with a prosecutor in a criminal case. And that is our submission. And what the judge says is, I consider that whilst Mr Smith may have made use of one or two matters which might be regarded as prejudicial, that at times he deployed no more than a touch of rhetoric, that on at least one occasion the evidence strayed into matters not formally in issue on this application, and that he relied upon matters which were merely consistent with his case rather than probative of it, Mr Smith's general approach was, fairly incorrectly, to let the facts adduced in evidence, and which were relevant to the issues in dispute, speak for themselves. Now, with the greatest respect, I think both to myself and to my learned friend, neither of us really get very much out of that at all. The judge is not saying that as a matter of principle, in a civil contempt, the applicant has to behave as a dispassionate prosecutor. He doesn't say, I accept the submission for Mr Abliazov. Nor, for that matter, does he say, I reject the submission of Mr Smith, which is our submission that in a civil contempt, inevitably the applicant has a personal private interest to pursue. So it's by definition not going to be a dispassionate prosecutor. In a sense, he sort of dodges both, well, dodges as an unkind way of putting it. He simply doesn't need to address either legal argument and simply makes a finding that the application was proceeded in a way that wasn't abusive. But neither side can really claim, I mean, I would like to persuade you that he certainly doesn't disagree with Mr Smith's submission. And that is our submission. An applicant in civil proceeding, in a civil contempt, does by definition have an interest, an axe to grind, so to speak. He doesn't reject that submission. He certainly doesn't endorse the submission that an applicant in civil contempt...
But it is the point that the reference to Mr Smith's general approach being to let the facts adduced in evidence speak for themselves, a reference to the test that is applied to a dispassionate prosecutor. That's a phrase we've seen elsewhere, and I just can't remember where.
Yeah, I'm not sure I can either.
Perhaps it's the judge who picks it up.
Maybe.
That's where I've seen
Maybe,
it.
yes. But,
yes, sorry.
Yeah. No, I'm grateful. As I say, with respect, this decision, this interlocutory decision in Abliazov can hardly be held up as authority on the legal principles at play. It's a decision on the material that was in front of this particular judge. It is first instance, whichever way, whether you find he was sympathetic to Mr Smith's submission or sympathetic to the other side's submission, it's not binding on you. It is simply a submission, simply a decision in which those submissions were recited, and the judge reached the conclusion that he did on that material.
Maybe the truth lies somewhere in the middle. The judge may, obviously, we haven't heard all the arguments yet, but may have overstated it by saying serves the public interest as much as it does as private litigant pursuing its own interest. I mean, it is clear contempt application is a serious thing, and perhaps the answer is simply no more than that. It's a serious thing. Must do it in good faith for one of the legitimate objectives. Mustn't harass, mustn't be vexatious, mustn't be frivolous.
And mustn't be unfair.
It mustn't be unfair, mustn't mislead.
Yeah. Essentially,
I mean, that
rules that should apply in any civil litigation, really. Yeah.
So does the applicant in a civil committal have any added responsibility over and above conducting civil litigation normally?
No. In my submission, he doesn't. And there's no authority to say that he does. There's no reason why he should, because it is an adjunct. Although there is obviously a public interest in court orders being upheld generally. In relation to civil contempt, you are necessarily dealing with a situation where the applicant has an interest, and therefore it is part of the process of adversarial litigation.
So you say it doesn't matter that the consequence could be that the respondent could lose his liberty?
Well, it's not that it doesn't matter, it's just that that doesn't impact on the obligations of the litigant.
It's why
on the
the
other
process
side.
is described as quasi-criminal.
Yeah, well, the fact that it's quasi-criminal does have its own significance, namely that the standard of proof is the criminal standard. Sorry, I just had a note which I think I passed over on that. Yes, I think the authorities seem to suggest that certainly the two significant consequences of the proceedings potentially leading to imprisonment or some other form of penalty are that the charge has to be clearly and precisely stated, and the charge has to be proved to the criminal standard, and that I think is the incidence, the significance of the proceedings being quasi-criminal, but they don't alter the ordinary obligations on a civil litigant to behave proportionately, responsibly, honestly.
So Mr Smith QC was a bit of a wimp, was he? When he submitted that the bank was not wholly to be equated with a prosecutor in a criminal case. You just wouldn't have bothered using the word wholly at all. You just not in any way to be equated with a prosecutor in a criminal case.
Well, to say not in any way might be interpreted as overlooking the 2 points I just mentioned, in the sense of having to state the charge clearly and having to prove it to the relevant standard. But in terms of...
But that's not talking about the role so much of the litigant, that's just talking about a procedural part.
But I mean, what's interesting, one concentrates on paragraph 143.
Of the judgment?
Yes.
In our case.
In our case. I mean, there are some... He seems to be saying almost that the lawyers take on the role of prosecutors.
Yeah.
That, as it were, the client is the complainant.
Yeah.
And I say that because one can see it from the tone of much of this judgment that Ms Berard is criticised very heavily.
Yeah.
And if you read the second sentence, the legal representatives need to understand their role as officers of the court is acutely pertinent. So it's almost that analogy.
Yeah.
The lawyers become the CPS, the complainant is the client, complainant / victim, and the... I mean, one question I have for both sides is, looking at paragraph 143 and the rest of the judgment, what duties would a full private prosecutor have over and above the duties that the judge identifies here as lying on your clients?
Well, I'm not particularly experienced in criminal process, but I am aware of the fact that a prosecutor has an obligation to provide disclosure of all unused material.
Yeah, so unused, full and frank disclosure, I guess, would be one thing. Unused material.
And the judge himself partly answered that question by suggesting that it was wrong even for the partner involved in the civil litigation to be the partner handling the committal application.
I mean, so you object particularly to act generally dispassionately and then let those facts speak for themselves. Now, Mr Justice Teare said fairly and correctly let the facts adduced speak for themselves, but it can't be suggested that, for example, you're not allowed to make submissions.
No, exactly so.
And submissions in your client's favour.
Yes. And adduce evidence that you consider demonstrates the contempt.
Because you have a private interest in it.
Yeah.
And so you would say it goes no further than inevitably in a civil contempt proceedings, the applicant has an interest, because there is the order or the undertaking, and thereafter they should behave like proper litigants, and everything they do should be fair. But that doesn't mean that they can't make submissions and do what a normal litigant would do.
Absolutely.
And when you look at the immediate, the sort of private interest aspect, it goes beyond the specific breach, doesn't it, depending on context. So, for example, a person can have a legitimate private interest in drawing this allegedly serious misconduct to the court's attention so as to prevent it happening again between the same parties in 3 years' time.
Yes, absolutely.
To put a marker down that when we don't take this lightly, even if we've been paid, and what have you.
Yeah, absolutely.
So all sorts of potential private interests, legitimate private
exactly.
interests.
And we drew attention to one authority I haven't taken you to, but you may recall that we mentioned in our skeleton the case of Guildford Borough Council and Smith. I'm not going to take you to it, but essentially that decision, it's Authorities Bundle 1 Tab 7, that decision makes exactly those points. That there are significant differences between a prosecution and a civil contempt, precisely for those reasons. TBD and Simmons, I was asked to address you on, and that is in volume 2 of the Authorities at tab 30. The position in that case, you may already be well aware, is that the case involved litigation between the former employer against the former employee and against the new company which he's working for. An injunctive relief was granted, including a search order, and that was then not complied with, and an application for committal was made. Page 752, right towards the back, paragraph 246. Yes, there is a quotation of 3 paragraphs from the judgment that's under appeal in front of you. So yes, that certainly appears to have been cited with, was cited with apparent approval. We would offer 4 short submissions as to what you get out of that. The first is that the observations that were in fact being made in the case in hand, in TBD itself, were being made in the context of a case where permission to apply for committal application was required. And one sees that from paragraph 62, page 705. So, and since that was a case requiring permission, the court's eye was not, by definition, was not on the ball that I am inviting you to play with. The second point is that what was said in that case on this issue was actually obiter, because it was said, having already decided that there wasn't a sufficiently serious case for contempt. And you get that from paragraph 241. Where the court says it's academic to consider the point that is then discussed in 246. Third point is that it is not apparent from this report whether there was in fact any argument at all as to whether the judgment in this case on this point was correct in relation to a civil contempt. One assumes there wasn't, because it wasn't a case involving a civil contempt. It was one requiring permission. But in our submission, you don't get any assistance from passing obiter approval in a different context on a point that wasn't argued. The final point is...
You say it's obiter. It's obiter in relation to one of the... Is it in relation to one of the respondents, but not the other? At the end of paragraph 241, he says, I nevertheless propose to deal with this issue because it bears upon the application to commit Mr Simon.
Oh, I'm sorry. Yes, I see. Sorry. Yes, fair enough. Yes.
I don't know where he comes back to deal with it in his discussion in relation to Mr Simons.
I hope to get back to you on that, but point taken. The final point I was just going to make, and this is one of the themes that can come up in contempt. The issue that arose in the TBM case arose while proceedings were still ongoing. And one sees that from 242. The quote from the judgment below in that case.
Yes.
The fact it was attempted to gain permission to bring committal proceedings whilst the proceedings were ongoing, and having quoted the judgment in this case in 246, the court then says in 247, in my view, Mr Justice Marcus Smith was entirely correct to conclude that the conduct of TBD and Acuity in writing the 1st of April 2019 letter, sending copies of that letter to third parties and pursuing the application against Mr O'Boyle in the manner in which they did demonstrated a fundamental misunderstanding of their role with respect to committal proceedings, in particular committal proceedings prior to trial. Now, I merely mentioned that as one of the many points because it has been said that one of the things the court disapproves of is using committal proceedings in a way that is oppressive during litigation. We saw the discussion about whether or not a legitimate purpose was being pursued. I think it was Tinkler and Elliott, or Integral, in using the threat or the actuality of committal proceedings in order to force a settlement. Now, it is one of the issues that applicants in committal proceedings need to address, is when to bring committal proceedings. Are they going to be accused of oppressive behaviour if they do it during the litigation? Or are they, as in this case, then going to be accused of being vindictive if they do it after the litigation ends? There is, to an extent, a bit of a sort of catch-22 that an applicant may find himself in. And I just wanted to draw that to your attention because it does feed into the argument on Henderson and Henderson, which I'll deal with very briefly in a few moments.
And it's my fault. Paragraph 242 of TBD
Yep.
gave 3 reasons for deciding to dismiss TBD's application. Just give me the reference, if you would, to what that application was.
So it's...
to commit for contempt. Was it not for breach of an undertaking? In that sense, wasn't it a civil?
I think it was it was a civil contempt. I think it was a breach of an injunction rather than an undertaking. But it was a civil contempt. So not one, I think, in which.
So I understood you to be making a distinction on the basis that this was the observations were made in the context where permission to apply for committal was required.
Oh, sorry, no, I'm getting the cases mixed. Yes, so paragraph 62, page 705, TBD applied pursuant to Rule 81.17 for permission to bring committal proceedings against Mr Simmons in breach of Rule 81.14, neither the application notice nor the draft order. So
it's my fault. So it was definitely a criminal. It was a criminal.
It was
contempt.
It was a case requiring.
I see, and one of the reasons was that TBD was relying upon, for the purpose of the criminal contempt proceedings, on material obtained in breach of an order.
Yeah.
I see. Thank you.
That's it. Yeah. The other case Milan Friend refers to is Cole and Carpenter, which is in the same authorities bundle. In fact, it's the next divider, tab 31. this was rather a more unusual case. It was a dispute over an alleged contract for an exclusive right to sell a Picasso painting. Yes, again, there is citation of the judgment of Mr Justice Andrew Baker in this case by Mr Justice Trower. In that case, at paragraph 32, which is at page 770, and my learned friend cites that as being recent approval of the approach taken by Mr Justice Trower, approval of the approach taken by Mr Justice Andrew Baker in our case. But again, if we just note a couple of points of distinction. The first is, this was again, the Cole and Carpenter was again a case requiring permission. It was a criminal contempt. We see that from paragraph 1. So again, it was a case in the KJM Superbikes category where the question of the public interest was at play and the role of the applicant as fulfilling a public function was in play, so not our case. And that is clear if you then turn to paragraphs 25 and 26 on page 767, where his lordship quotes KJM Superbikes in paragraph 26, and you'll remember the passage from that I've already read to you. Whenever the court is asked by a private litigant for permission to bring proceedings, it should remind itself that the proceedings are public in nature and that ultimately the only question is whether it is in the public interest for the proceedings to be brought. None of that is relevant in our case with respect. And paragraph 27, the focus on the need for the court to be satisfied that it's in the public interest for contempt proceedings to be brought has been a consistent theme in the approach adopted by the court to applications for permission in this context. That's the first point. It was a permission case in relation to criminal contempt. Second point, as with TBD, it's not apparent whether there was any argument in that case on the distinction that we are seeking to draw between civil and criminal contempts and the inapplicability of the public interest, public prosecutor type principles to civil contempts. Third point, while we have it open, is that it also touches on the sort of catch-22 issue. If one looks at paragraph 83 on page 779, in my judgment, the present case is one in which whatever the position may be after the trial, bringing the contempt application at this stage would be premature, disproportionate, and contrary to the overriding objective. So the question of timing, is it appropriate to bring contempt until after the civil proceedings have ended, is a relevant consideration. And the final point, self-evidently, it is another first instance judgment, plainly not binding on this court, and in the absence of any apparent argument in relation to the point I'm addressing you on, not of any real assistance in your decision about whether or not to allow this appeal. So that's the second main ground. We submit that the judge went awry in holding that there was any relevance, any application of the sort of public prosecutor role. Third ground of appeal is the supposed relevance of Mr Chernukhin's knowledge of the re-domiciliation at the time when he accepted the undertakings. We're getting to a stage in our submissions where we are going to get a little bit into the factual material, but I need, in the time available, just to set out our stall on this. So can we just look, please, at the judgment at paragraph 68, page 114.
Mr. Gray, could I just say that I appreciate that you are, as far as the timetable goes, under time pressure, but these are very important issues, and if necessary, we will sit a little late. So don't hurry yourself too much.
Thank you. Thank you, my lady.
I'm sorry, we were going to paragraph.
To paragraph 68.
Thank you.
114 of the core bundle. I just want to walk through with the court what the judge was actually saying. He says an adverse inference was then to be drawn, Mr Pelleqc argued, from Mr Chernukhin's evasiveness on the point through the Part 18 responses, misleading presentation of the case through Ms Berard's evidence, and failure to give evidence himself, such that it should be held, and this is what he says he accepts ultimately, A, that Mr Chernukhin was aware at all material times, i.e. from before the undertakings were even given, that EN Plus was actively considering a re-domiciliation to Russia. B, that he was untroubled by the possibility that the shares would move from Jersey to Russia, and content to treat the undertakings as acceptable alternatives to a continuation of the WFO, notwithstanding that possibility. And C, that the motivation for the contempt application was therefore was not a belief or concern on Mr Chernukhin's part that the re-domiciliation had somehow prejudiced or threatened to prejudice Mr Chernukhin's interests. I agree again.
Just interrupting unhelpfully, that just goes to show the overlap between fundamental the last point, fundamental misapprehension and breach. It's a good example of where one feeds into the other.
Yeah. And if we are right that Mr Chernukhin's personal motivation is entirely irrelevant to the question whether or not there has been a contempt and whether or not the court should hear that contempt application. All of this is entirely immaterial. But we say it's misguided anyway, and I know I'm engaging with what on the face of it is a finding of fact. But how, with respect, did the judge actually get to any conclusions in relation to this that support the findings he did? Mr Chernukhin was aware at all material times that EN Plus was considering a re-domiciliation to Russia. Well, he may well have been aware, right? I have to accept on the face of the judge's findings, he was aware that that was a possibility. But he wasn't aware that it would happen. And he wasn't aware that it would happen with Mr Deripaska voting in favour of it. And he wasn't aware that it would happen with Mr Deripaska voting in favour of it and not coming back to court beforehand to clear the ground. So why is it that the judge seems, with respect, determined to find something to criticise in Mr Chernukhin in relation to matters which would have been entirely speculative as to whether they happened at all, would there be a re-domiciliation, and entirely speculative as to whether they would have impacted on the undertakings if they happened, or whether, as Mr Deripaska himself accepts he should have, if Mr Deripaska had gone back to court, explained what was planned, asked the court to release him from his undertaking, and thereby give the opportunity to my client to obtain substitute security. It is, with the greatest respect, simply illogical for the judge to find any relevant material against my client at all in this context.
So A and B lead to C. So C is the key point.
C is
correct?
The key point.
So it's saying, I hold he was so aware, B so untroubled, therefore motive, if relevant, was not genuine.
Yeah. And so, in a sense, taking it in reverse order, we say C is the wrong question anyway, because whether Mr Chernukhin thinks that there has been a breach, it's got nothing to do with whether there has been a breach and whether it's an abuse to bring in front of the court what on the face of it is a serious breach. But in our submission, you shouldn't even have got to C, because A and B are simply illogical. So I accept where a judge at first instance has made a primary finding of fact, it's difficult to appeal it. But what the judge is here apparently trying to do is to draw inferences as to motivation on the basis of what are, with greatest respect, entirely illogical leaps. So with that, if one looks back...
It's as if, I'm sorry to interrupt you, Mr Crowe, but it's as if the judge is actually saying that A and B mean that Mr Chernukhin can never have taken the undertaking seriously, so they didn't matter.
It does rather... It's difficult to know what to say other than that. I agree. And entirely parallel to that, as I say, it's always difficult in this court to challenge findings of primary fact.
But this is simply an inference.
That is an inference.
Without having heard from Mr Chernukhin. I mean, what did he envisage? That Ms Berard would give evidence for a day, I don't know how long she was in the box, and then Mr Chernukhin would go into the witness box for another day or two. This is all in support of an abuse application.
I don't think Mr Chernukhin actually made a witness statement.
No.
In support,
No,
so
the judge wasn't happy with that.
No, indeed,
That's my
indeed.
point. So
No,
I'm trying
quite.
to work out what he would have.
Oh, I'm sorry. I see what you mean. Yes. Apparently, his preferred approach would have been to sort of, if the criminal analogy is proper, his approach would have been to cross-examine the CPS case officer as to why he was bringing the prosecution, which really is, with respect, wrong. So that's the sort of the findings of knowledge. If one then looks at, well, what is the supposed relevance of all of this? One has to go back to paragraph 65 for that, where the judge says a major focus of Mr Deripaska's response to the contempt application of Mr Pillow's cross-examination was the claimant's awareness over time of the pursuit or possible pursuit of VN plus of a continuance in Russia, all within its response to the US sanctions. In charging Mr Deripaska with contempt and inviting the court to consider punishing him for it, the claimants took on a quasi-prosecutorial role, no they didn't, in the public interest. As I explained further below, I agree with Mr Pillay that, if prior to the summer of 2019 the claimants were aware, yet made no complaint of, the planned re-domiciliation, that was plainly irrelevant, because it went to the claimant's prosecutorial motive. Well, with the greatest respect, even if motive is relevant, why? Why does it go to motive? That Mr Chernukhin knew there was a possibility that there might be a re-domiciliation. He didn't know there would be. He didn't know Mr Deripaska would participate in it. He didn't know Mr Deripaska wouldn't come back to court. So he says it went to the prosecutorial motive and to a fair assessment of the seriousness of what Mr Deripaska is alleged to have done. Well, why? Why is Mr Chernukhin's personal opinion relevant to the court's assessment of seriousness? The question of whether or not there's been a contempt, and if so, is it a sufficiently serious one to merit a sanction, is preeminently a decision for the court. Why on earth should Mr Chernukhin's personal view on that have the slightest significance? So he says it's relevant to a fair assessment of the seriousness. Indeed, it might be exculpatory generally on whether Mr Deripaska should be treated as in contempt of court. Again, a fortiori. How on earth can that be right? How can the personal opinion of Mr Chernukhin be
the only way that there could be some sort of exculpation would be if there was some waiver,
yes,
some consent, some
yes,
informed consent,
yes,
or something along that those lines, but knowledge seems to me at this stage, speaking for myself, to be, as it were, difficult to see how it could be exculpatory.
Well, I will respond if my learned friend seeks to defend that, a line of reasoning. And the final one is because some of the claimant's evidence in support of the contempt charge was rendered misleading, if indeed Mr Chernukhin had prior knowledge of the re-domiciliation but raised no concern about it. And it is interesting that knowledge of the brackets planned re-domiciliation in the middle of the paragraph has been elevated to knowledge of the re-domiciliation by the last line. That then, I think, does leave me needing to deal with the fourth ground, which is sort of picked up right at the end of paragraph 65, which is the supposedly misleading evidence from the claimants. And I think the most convenient way of dealing with this is to look at and go through paragraph 156 of the judgment, which is page 141.
What about the last point
Sorry.
in that the last sentence in the paragraph we've just looked at, which was that your evidence was misleading in the sense that you didn't refer to awareness of what was in the public domain.
Sorry, yes, that's
which is sort of paragraph 155, isn't it? As well.
Yes, I think that's probably right. Well, two answers to that. I think, as always, the first is, as a matter of law, it's an irrelevance. As a matter of judgment, we invite you. We would invite you to look at Berard 8 and form your own view, which you can form as well as the judge could, as to whether that presented anything misleading about this. What she said was, the first time Mr Deripaska's lawyers drew our attention to the re-domiciliation was the May 2019.
Well, on its face, that's obviously correct. But what wasn't said was, although we knew from what there was in the public domain.
No, that's right.
And that would have been a fuller explanation.
Although she does, in fact, give a description of what was in the public domain from before that. In the lead up to that observation, I'll get you the paragraph references. I haven't got that bit of a note in front of me at the moment, but she does give a description of what's in the public domain. She doesn't say, and my client knew this at the time. I entirely agree. But she does give a description of the re-domiciliation. Can I then just very briefly run through the sub-paragraphs of paragraph 156? Because this is these are the sort of the top picks of the supposedly misleading evidence, or not the whole truth. So 156.1, there was no mention of the involvement of Quinn Emanuel. Clifford Chance were then on the record. There was no mention of the involvement of Quinn Emanuel, although their involvement was plainly relevant, even if the claimants were not waiving any legal advice or litigating privilege or misconduct. So it is said that my client's evidence was misleading because he didn't say that he had a wider legal team that included 2 other firms as solicitors. Our submission in response to that is that there is absolutely nothing relevant for the court to know about how many lawyers are advising an applicant before it. If the answer is, and I think this is in fact what my learned friend is saying in his skeleton, is that the judge should have been told what Quinn Emanuel and Mishcon Derea knew and what they were advising my client, well, that, with the greatest respect, is not a criticism that can possibly be made, because that would be tantamount to saying that it's misleading not to tell the court what your own legally, professionally privileged material is. And that is so fundamentally erroneous, it's difficult to know where to start in answering it. No party can be criticised for not waiving legal professional privilege. It's the most elementary and immutable right in litigation.
But was it ever said by your clients that they didn't have access to lawyers,
No.
or the only solicitors were Clifford Chance, or any positive representation?
Sorry, I need to tell.
Sorry.
Can I give a more coherent answer in
Yes.
a complete answer? I'm absolutely not aware of the slightest indication that there was no other lawyer. I'm being prompted that there was in fact an awareness on the other side that Quinn Emanuel and Mishcon Dere were involved. But I don't want to sort of make an assertion without being able to give you some chapter and verse on it. And the short answer on in relation to that is that it is simply an irrelevance how many firms of lawyers are involved. Little 2. It fails to mention Miss Berard's own personal knowledge of the proposed re-domiciliation prior to the May 2019 letter. Well, again, in our submission, 2 points. One is, as a matter of law, all this was irrelevant, but not mentioning what a lawyer knows cannot possibly be misleading the court, because any explanation of what the lawyer knows is immediately sucking one into the quagmire of waiving legal privilege. Now, I've just found it, Milady. I said that Ms Berard 8 gives a description of the re-domiciliation. It's paragraphs, I'm not asking you to go to it now, but it's paragraphs 55 to 61 of her witness statement, which is in tab, the supplemental bundle 1, tab 15, at page 203.
Thank you.
The other point I think that's made in little 2 there, it says, it gave the very clear impression that neither Mr Chernukhin nor any of his advisors knew anything about it prior to that letter. That was seriously misleading. Well, as I say, we do invite you to read those passages in Berard 8, 55 to 61, and form your own view, because this is just inference, or it's a judgmental comment from the judge, and you're in as good a position as the judge was to express a view as to whether that is a remotely fair comment on her evidence. Ms Berard in cross-examination refused to accept as much, and I'm not prepared to say she was not being honest in her answers. I note that the same wrong impression that the claimants knew nothing of the re-domiciliation prior to May 2019 letter had been given to the Jersey court. Well, that, in our submission, is not a road the judge should be going down. He was assessing whether the proceedings in front of him were an abuse. For an English judge to be commenting on whether or not something presented in Jersey was or wasn't misleading, in our submission, it is simply a wrong road to be going down, and it's particularly inappropriate for something that's happened in Jersey proceedings to be taken into account in deciding whether English proceedings are or are not abusive. So we, with respect, don't accept that paragraph 2 is a justifiable criticism of the evidence that was presented. Little 3. Even on Ms Berard's explanation of that last matter, namely that she did not mean to convey, she had not meant to convey a lack of prior knowledge of or understanding about the re-domiciliation, only a failure to appreciate that it might be said to impact on the undertakings, her affidavit was thus not the whole truth she should have given the court. We just don't understand that thus. And B, the lack of candour was significant, since her explanation was substantially exculpatory for Mr Deripaska. Again, with the greatest respect, we just don't understand that at all. That would have been so in any event, but especially in circumstances where the case to be presented to the court was to include claims that Mr Deripaska's breach was obvious, flagrant, egregious, and compounded by his failure to admit his supposedly self-evident guilt. Well, that appears to be a criticism that the claimants presented their case on the basis that there was a clear breach of the undertaking. If one just steps back a minute, it would be a rather odd state of affairs if an applicant brought a contempt application not believing that there had been a clear and obvious breach of a court order. So it can hardly be a matter of complaint that the claimants did think that there was such a breach. The suggestion that Ms Berard said that she had not previously been alive to the risk of a breach is, with the greatest respect, not a criticism of the candour of the evidence adduced at the hearing. Even if one accepts an inference that Mr Chernukhin and his advisers knew in advance of the possibility of re-domiciliation, as I've said before, they cannot have known that there would be a re-domiciliation. They cannot have known that Mr Deripaska would have caused a vote in favour of it, and they cannot have known that he would have done that without coming back to court first. So to suggest that any of that, the comments in paragraph 3 are criticisms of Ms Berard's candour with the court, in our submission is just unfair and incorrect.
And the reference to the lack of candour was significant since her explanation was substantially exculpatory takes you back to your previous ground of appeal, and whether in some way it's being suggested that there was some trick or trap in the undertakings.
Yeah, absolutely. Little 4, the court says it wasn't satisfied that it had been given full disclosure in relation to Mr Chernukhin's knowledge of the proposed re-domiciliation. Again, the position that was taken, as presented in legal argument, was that that was an irrelevance. The judge took a different view. He says he should have been told about it, but that does not display any lack of candour in the sense of a failure to give to the court what a party knows it should be giving. It was a situation in which my client's then case, being presented by leading counsel, was that Mr Chernukhin's prior knowledge was an irrelevance. We accept, we don't like it, we accept that the judge disagrees, but for the judge to disagree and to say that it was misleading for Mr Chernukhin not to give disclosure, full disclosure of the documents in relation to that, in our submission, is to add insult to an injury. 5, it said that there is an inconsistency between an earlier and a later witness statement by Ms Berard. Maybe there was. Sorry,
where are we?
Sorry, so it's Roman 5 on page 142 of the judgment.
Right.
So what is being pointed out is that in 2 witness statements, 14 months apart, it's being said that there was an inconsistency between the evidence that was presented at one stage on the basis of solicitor's knowledge in June 2018, immediately after the at the time of the undertakings, and in August 2019, after the re-domiciliation had come to light. Whether or not there is an inconsistency between 2 solicitors' witness statements made 14 months apart in our submission is not a relevant issue in determining whether or not a contempt application is being brought in an abusive manner. And in our submission, it starts to feel to the latter end of this paragraph as if the judge is genuinely just looking for sticks with which to beat our clients.
Can I just look at the last sentence? I mean, we don't have that affidavit, I don't think.
No, we don't. And I apologise, we can...
But does it... The claimant's position in June 2018 is said to have been, in terms, that it didn't matter to your clients where the share certificates were.
Yes. I think there are words to that effect in the witness statement. That isn't a relevant question in our submission, because a solicitor giving an affidavit is only giving an affidavit on the basis of her then understanding or her then instructions. And whether or not that remains the understanding as at the time when the undertakings were in fact given is another matter. Whether it affects the correct interpretation of the undertakings is another matter. And whether or not it demonstrates that an application for committal, which is otherwise well-founded, becomes an abuse because of something that should have been said a year and a half earlier. Is the mouse submission?
Well, I mean, I was thinking more in terms of breach, and you stressed very firmly this morning the importance of the share certificates being in London and available for direct enforcement. I mean, at least on its face, it appears to relate to that issue.
That is a fair observation, Lord, and as I say, as you say, that witness statement is not, in fact, in the Court of Appeal bundle. Clearly, neither side thought that needed to be added to the material. I'm conscious of the time. Can I take a bite out of my reply and just keep going for another 10 minutes?
Can we see it?
Yeah, I was going to say, is it possible that we could see that third affidavit?
I'm sure copies can be made available, yes.
I'd be grateful.
Yep.
And you're saying 10 minutes more.
Is that acceptable?
Yes, that's acceptable.
As I say, I'll take it out of my reply.
Yes, Mr. Piller will not be put to any detriment, I assure you.
Paragraph 6, in the same 7th affidavit, Ms Berard gave the court the impression that the shares had been tradable on the London Stock Exchange when Ian Plus was domiciled in Jersey, but no longer after the re-domiciliation. The truth, however, as Ms Berard knew, was that the shares had never been tradable because they were not part of the GDR programme, and the GDR programme had been unaffected by the re-domiciliation. It's very difficult to understand why the judge regarded this as misleading evidence, let alone relevant misleading evidence, because everybody knew that the shares that were subject to the undertakings were not tradable. Of course, Mr Deripaska knew that. They were his shares. And as Ms Berard said in cross-examination, it was, I think she used the word sloppy language, or accepted the suggestion that it was sloppy language. But these things happen in preparing witness statements. It's not misleading evidence in the sense that nobody was going to be misled because the other side knew the true position. She could have chosen her words a little more happily, a little more accurately. It's not misleading evidence that turns an application that is otherwise well-founded into an abuse, because nobody was going to be misled. And finally, 7, Ms Berard was driven in cross-examination to accept rightly that knowing of the proposed re-domiciliation did not make it obvious that the undertakings would be affected. Yet her sworn evidence for the hearing before Mr Justice Teare on the 3rd of July was that it was obvious, indeed so obvious it was difficult to see how the undertakings were not infringed. Well, that again, with the greatest respect, is a thoroughly unfair observation by the judge. Of course, the possibility that there might be a re-domiciliation does not necessarily lead to the conclusion that there is going to be a violation of the undertakings. Because, as I've said more than once, there may not in the event be a re-domiciliation looking forward. It may not involve Mr Deripaska doing anything. It may not involve Mr Deripaska doing something without having gone back to court. So, looking forward...
Then what about her sworn evidence for the hearing before Teare J?
I'm sorry?
What about her sworn evidence for the
Yes,
hearing before
by
Teare J?
then, we're in July 2019.
I see.
That's after the re-domiciliation, when we then discover, yes, there has been a re-domiciliation, there has been a shareholders resolution. Mr Deripaska, we are told, caused his company to vote in favour. So yes, by then, absolutely there's been a breach. So we go to court and we complain. But that, again, with the greatest respect, is just a thoroughly unfair criticism of the evidence that was adduced. Can I just then deal very briefly with Malone Friend's additional grounds for upholding the judgment, so that, again, as I say,
Do you deal with 158 to 160 in your skeleton? So heavy-handed, aggressively partisan,
tendentious comments, prejudicial material. I can't say much in relation to that, other than, as I say, to repeat my invitation to the court to read Berard 8 and form your own view as to whether you think that is fair. We just say it isn't. It's not a finding of primary fact, it's a comment, judgmental assessment, and we submit that it is just not a fair one based on the material in that affidavit. One of the particular things that is made in that, and it may be worth making just this specific point, is that Mr. Justice Andrew Baker seems to think it was unfair, prejudicial and irrelevant to point out that the Arbitration Tribunal and Mr. Justice Teare had both found Mr. Deripaska guilty of having presented a false case and having bribed a witness to do so too. With the greatest respect, it is extremely difficult to see how that cannot be relevant when one of the issues in the committal application was going to be the credibility of Mr. Deripaska's evidence that there was no instruction as to how the shares should be voted. His credibility was in issue.
Propensity, all of the rest of it.
And the gravity of any breach, if there was established, would plainly be relevant to sanction. Mr. Justice Andrew Baker seems to have taken again the presentation of the case because we pointed out what the court had already decided at a trial.
But the second half of paragraph 159 is that the judge took against the way in which Ms Berard gave evidence when she was cross-examined because basically she was argumentative instead of
well, she's a
answering the questions.
With the greatest respect, where's all this going? It's an application for committal against Mr. Deripaska. It's not a test of the instructing solicitor on the other side as to how well they don't do in cross-examination. It's not even the client. Very, very briefly, additional grounds for upholding the judgment are outlined by Malone's friend. He says Henderson and Henderson. First of all, he says that the committal application should have been brought in front of Mr. Justice Teare in July of 2019. Our submission on that is that the principle, the rule derived from Henderson and Henderson may be applicable in interlocutory applications, but it simply isn't a relevant point against our client in relation to the circumstances of this case, because the test is not whether an application could have been brought earlier, but whether it should have been brought earlier. And all parties seem to have been working on the basis that although the possibility that a breach of the injunction of the undertaking had been committed, that wasn't the issue that Mr. Justice Teare was being asked to deal with. And the sort of the catch-22 point that I pointed out in some of the case law is relevant here, because no doubt my client would have been criticised for being oppressive and prejudicial if he had been bringing an application for committal at the same time as asking for a variation of the existing injunctions to give him protection. The second ground on which my learned friend seeks to uphold the judgment below, as he says, impossibility of performance. That I think we've already dealt with, and I don't have anything that I think I need to add on that. The third point he says is that the undertakings were open to different interpretations, and therefore there can't have been a clear order and a clear breach, to which our submissions are, yes, the undertakings are absolutely clear, and the judge simply did not address the language used in the context in which it appears. The fourth point my learned friend makes is that he says that the undertakings had been discharged and any contempt had been purged by the time that the committal application was brought, because the undertakings were there to protect my client's ability to get payment under the judgment, and he had been paid under the judgment before the committal application was brought. As a matter of chronology, that is true. It does not mean that there had been no contempt. The contempt occurred significantly before my client was actually paid, and only, as it happens, after mounting pressure through those hearings we were looking at in the chronology in August and September, which actually led to orders for Mr Deripaska to sell assets in order to meet the judgment. In our submission, there was no purging of the contempt at all. In order to purge a contempt, one needs to issue an application, apologise to the court, and make good any losses. And it was the losses in the damages claim, which we can't now pursue, that were incurred. The final point my learned friend seeks to rely on by way of an additional ground for supporting the judgment is that he says that the committal application was disproportionate. In our submission, that adds nothing to his case. Either he is right on the grounds that the breach, if there was a breach, was technical or involuntary or not serious, in which case he doesn't need disproportionality, or he's wrong on those. If he's wrong and the breach was not merely technical but serious, then the application for committal was not disproportionate. So in our submission, the various 4 or 5 grounds for the additional grounds for upholding the judgment on which my learned friend relies add nothing of substance to the argument that we've had on the basis of the judgment as it stands. And unless I'm going to be either prompted from behind, I'm grateful. My learned junior points out that if we were to look, they'd ask you to get these out, if we were to look in supplemental bundle 2 at page 502, page 192 of the transcript, my learned friend, Mr Queen's counsel, who was then appearing, said, "Now, my lord," to the judge at the hearing on the 9th of June, "Now, my lord, the next question is the penultimate point, Quinn Emanuel's involvement. Just so that no one is under a mistake, I myself, I think, informed your lordship or Miss Berard, and therefore your lordship, when I was cross-examining her yesterday, that we had been told that Quinn Emanuel had been instructed for the Chernukhin parties in June 2018. Unless there are any questions from the bench, those are our submissions in opening, and I'm sorry to have overrun.
Thank you very much indeed. Mr Pillow, now you have lost a quarter of an hour. At the moment, I'm certainly willing to make that up this afternoon. And so I think we'll proceed in that way.
I'm very grateful, thank you very much. What I was proposing to do, perhaps orthodoxly or conventionally, was to deal with the first ground of appeal first, and then the second ground of appeal second, and introduce a few points on the abuse argument by way of overview, and then move on to answer questions of the interplay between the abuse issues and the merits of the breach argument, which was the subject of some discussion with Mr Crowe earlier, and to set out the respondents' position as to how they fit together and what's in issue in this court and how that impacts on the abuse issues. I don't need to say very much by way of introduction to the abuse judgment itself and the way it's structured, because Mr Crowe has taken you through the 4 facets, if you like, of the judge's judgment that came together to render the application, in his view, an abusive process. They're all set out in turn from paragraph 155 of the judgment. Just by way of introduction, my learned friend said that he only has to succeed on one of the various grounds. It's not quite right, because it depends on which grounds he were successful on, if any. Of course, it will be no good to him in my submission for him to succeed, for example, in part or in whole on ground 1.4 or 1.3, if the misleading, the irrelevance of knowledge or the misleading nature of the evidence, for example, if he doesn't succeed in persuading the court that subjective motive is irrelevant in this kind of application, because that is a freestanding reason why it would have been it was abusive for this application to be brought with the motive as found by the judge. And it's important for the court to bear in mind in my submission that the appellant does not challenge findings of fact as to what his motive was, which was revenge, personal animosity and hatred, especially because of Mr Deripaska's institution of the private prosecution, which Mr Chernukhin wrongly attempted to try to negotiate the settlement of in the summer of 2018 and failed, and the judge found as a fact that that was the motivation for Mr Chernukhin bringing the committal application in November. So he doesn't challenge the findings of fact on motive, and he doesn't challenge the findings of fact, except in relation to his grounds on the misleading evidence, in relation to his failure to act as a quasi-prosecutor, his clients or their solicitors' failure to act as a quasi-prosecutor. So all of the judge's findings about the way in which the case was presented, short of the appeal on the specific facts in relation to misleading evidence and so on, are also unchallenged. So if the court were to find that, as I submit, is clear, a person in the Chernukhin party's position bringing a committal application was duty-bound to act as a quasi-prosecutor dispassionately, and all of those sorts of things, then, again, there is no challenge to many of, or most of the ways in which it is said they breached that particular obligation, and that would be a freestanding ground on which the appeal would succeed. A freestanding ground on which the decision on abuse could be upheld, regardless of whatever happens with the other.
Can I just pick you up on motivation? Let's assume that there's a different case, a perfectly straightforward breach of a worldwide freezing injunction, worldwide freezing order. It's absolutely open and shut,
Yes.
and millions are simply dissipated
Yes.
in breach of the order.
Yes.
And the beneficiary of the freezing order, the applicant, issues contempt proceedings out of revenge.
Yes.
Are those proceedings abusive?
Yes.
Right.
If that is the dominant sole or predominant motivation, my lady,
So
it's quite unlikely to be.
The judge refers to this predominant sole.
Yes.
There's some debate which he says he doesn't have to resolve, but you say there is such a test, and there's a question of predominance. It has to be predominant motive.
Well, it actually doesn't matter in this case because the judge found the only motive.
I know.
was
I'm testing your proposition. You say so if it's the sole motivation, that
Then
without
clearly it
more
would
renders renders civil contempt proceedings abusive.
Yes.
Thank you.
And as Mr. Justice Foxton said in the Integral Petroleum case, it may matter in some cases whether it's the sole motivation or whether there is a mixture, and one might get into a question on the facts. But we know in this case, both because there was a finding that the motivation was hatred and personal animosity, but also a finding that it was not to bring serious wrongdoing to the court's attention.
But that's premised on his finding there wasn't any serious wrongdoing.
No, in my respectful submission, it's not, my lady.
You'll take us all of that.
I will, of course. I will, of course. But there's no challenge to those as findings, and in my submission, they weren't premised on any assumption as to the merits one way or another, which was one of the ways in which the judge approached this in an appropriate and open-minded way. So I was going to show you, or just to remind the court, that the headings under which the judge brought the abuse conclusion together in paragraph 155 of the judgment, from 155 of the judgment. If I could just show you those and make a couple of points about. The first point he made in 155 was the failure, or the refusal, in fact, to be open with Mr Deripaska about the extent of the claimant's awareness of the proposed re-domiciliation and their consequent failure to explain to the court why they were content with the undertakings that were given, even though Mr Chernukhin knew that a re-domiciliation to Russia was in prospect before they were even lodged. Now, there's a further aspect to that, of course, which is not just that he knew on the findings of fact that are unchallenged before the undertakings were lodged that a re-domiciliation to Russia was in prospect, but also that he knew in the months that followed that, firstly, that the board of directors of N+ had voted in favour of the continuance to Russia in the autumn of 2018. That the judge found as a fact, and we know that because we eventually extracted emails that showed him getting press articles to that.
And where's his finding of fact on that, please?
That, my lady, is in relation to the press article to that effect at paragraph 69.
Thank you.
3, and they're all dealt with there 1 to 5, my lady.
Thank you.
I'll come back to further findings he made about knowledge. I'm not trying to be exhaustive, but if I can give you another reference that's helpful, I will. So there's that knowledge. Then there's the knowledge in December. It's at the particular point I was on, my lady, was number 5 in that on that paragraph, page 115, which is the Vedomosti article, which you'll see at the end of this paragraph, Mr Chernukhin and his lawyers from Clifford Chance read and at around the time it was published, and that told them not only that there was a board decision to re-domicile to Russia at that point, but also that there was going to be a shareholder vote that's said to be the flagrant contumelious breach on the 20th of December 2018. That was the news of it coming. The judge then found on the facts, and I'll see if I can get you the reference immediately, that in fact Mr Chernukhin knew that vote had taken place on the 20th, and he knew that it had approved the re-domiciliation to Russia at that time. That's paragraph 76. And that finding, my ladies, my lord, involved a specific rejection of Mrs Berard's oral evidence to the contrary. The judge found that she asserted there was no such knowledge, but she had no basis on which to make that assertion, and he rejected it as true. He said it was not true. So, my lady, the points about knowledge dealt with in paragraph 155 is not solely a question of what was in the factual matrix before the undertakings were actually given, which includes the knowledge that a re-domiciliation to Russia was in prospect. It includes the questions and the fact that at no point during the next 10 months or so, 8, 9, 10 months, did anyone on Mr Chernukhin's side, including Mr Chernukhin himself, or any of his lawyers, and there were lots of them, ever suggest or raise an issue that this impending re-domiciliation was going to give rise to a problem for the undertakings, let alone that it would be a serious, contumacious, flagrant, outrageous breach, as it has come to be described when the contempt application was made. And that is important context in my submission, both in the early picture in relation to the construction of the undertakings, but also when the court was looking at the seriousness of the alleged breach. Because we do say it lies ill in Mr Chernukhin's mouth to suggest this was a serious and outrageous event when he knew it was coming, saw it happening, watched it go past and said nothing to suggest that it was a problem. And the judge rightly took that into account when he regarded the evidence to the contrary as it came out in the committal application as misleading and cute, which it was, because it deliberately obscured the fact that Mr Chernukhin and his advisors had all of that knowledge going back many, many months. Now, I'll come on to develop how that mattered for the abuse application, but I just wanted to point out that that's the first limb, if you like, of the judge's decision in paragraph 155 and following. And there are 2 points to note. I may have already made one of them, but I'll repeat it if I have. The first is that, again, my learned friend, nowhere in the first 15 or 16 pages of their skeleton for this hearing do they mention any of that knowledge. it's a sort of taboo subject for Mr Chernukhin. And that is the exact problem that occurred, in my respectful submission, in front of the judge below. That they wanted to construe the undertakings and then analyse the behaviour of the parties in a vacuum, without mentioning that they knew exactly what was happening at all times as it was progressing.
Why does that matter? Why does that matter? I mean, it's forensic.
It's because, my lady.
I mean, why does it matter?
Because, well, it goes. I said partly it goes to construction, because there was knowledge prior to the undertaking.
How did it go to construction?
Because if both parties know that a re-domiciliation to Russia is in prospect, then when they agree an undertaking that says certain things, that is a fact to be taken into account in its construction.
Well, that doesn't appear anywhere in the judgment or in your skeleton, does it, Mr. Pillow?
Yes, I think it does, my lady. But I'll.
So just to understand, you say that because the parties knew of this possibility, that is a material piece of the construction exercise.
Yes.
Of the undertakings.
Yes. And the judge found that in terms when he said it's relevant to know that Mr Chernukhin knew of the re-domiciliation before he accepted the undertaking, but was content to proceed nonetheless.
Knew of the possibility.
Yes, knew of the possibility or prospect. And of course, there was also a prospect and possibility at that stage, widely advertised and known of, that if it wasn't prior to the Russian plan, that it was going to re-domicile to Cyprus. And that was in the listing documents and had been public for many years. And N Plus had, I don't know whether you picked this up, already re-domiciled in its past from the BVI to Jersey. And so one has to construe the undertakings, in my respectful submission, as the judge did, on the basis that the parties knew that this entity might, and the evidence is that it was necessary, in fact, I'll come on to show you that, re-domicile to Russia, but that the parties were both happy to give them in the terms that they did.
I find that very difficult to follow, but in any event, how do you deal, therefore, with the fact that RPC gives, the undertaking is given by B Finance and the shares are lodged, put it that way, with RPC?
Yes. Well, that, my lady, is a whole further can of worms, if I may say so. And it was really exemplified by my Lord Justice Snowden's question in response to what he saw in the material, the judgment, to the fact that there was also evidence that from Miss Berard, on behalf of Mr Chernukhin, that the location of the share certificate was not important. And I'll come on in a moment to explain why this is why it's very dangerous for this court to try to construe the tapestry of fact behind the undertakings when it hasn't had the benefit of the trial on the facts that took place before the judge, let alone a committal trial, which has never happened, and I submit should never happen. But my Lord Justice Snowden mentioned that. That reference to the claimant saying we don't care where the certificate is, what we want is enforcement against a Jersey company. That's what they said. Doesn't matter where the shares are. That in fact, you can see what was set out in my cross-examination of Miss Berard on the subject. And I'll just give you the reference in case it helps before we get the final document.
Well, then that wouldn't be so inconsistent, would it?
We'll have to look at exactly how it's put, my lady.
Yes.
But it's day 1, pages 73 to 74, bundle F, supplemental bundle 2, page 419. But it is quite easy, in my respectful submission, on an appeal like this presented in the way it is, for this court to think it's in the same position as the judge when it comes to construing the background to the giving of the undertakings. And
it's a question of construing the undertakings.
Well, in their factual context, my lady.
Well,
yes.
in the relevant, yes. But in traditional way of construction, not by going over the last 2 or 3 years worth of events.
Well, it depends how material they are to the factual context, my lady. I accept that, of course. But the factual context is very important in this case, in my submission, and it always was. And you'll see how the judge decided. Now, you may not agree with the way the judge decided the construction point, although I submit he was right. But the very fact that he did was the product of a lot of submission and evidence that you have simply not seen.
What was the construction point, as you put it?
Well, the construction point...
Which particular phrase or sentence do you say needs to be construed in any different way in light of the matrix than the ordinary and natural meaning of the words?
The particular one, of course, is when it says the underlying assets shall remain available for direct enforcement.
Right, so which bit of that phrase has to be construed differently?
Firstly, the underlying assets.
What do you say? We say, what does that mean?
We say that is notably not capital S shares, and what it means is the interest in N plus that is represented by 45 million shares.
Is that shares with a capital S?
That's a matter of construction, my lord. That is the matter of construction, but it's not necessarily the question the shares with a capital S. And I'm now digressing. But then there's obviously the question of what for direct enforcement meant, and there was rather a lot of evidence as to how that phrase came in to the undertakings and what it was perceived to mean, some of which may or may not be admissible.
Am I missing something? I mean...
my lady, you're missing a lot, but
yeah.
it's not all admissible.
Just normal principles of construction.
Well,
Are we looking at the subjective intention?
No, my lady, one was looking at, for example, I'll come on to this, the vice to which that particular wording was directed in communications between the parties. There was some evidence about that. It wasn't subjective intent, it was a matter of what they were trying to achieve with that wording. And the answer is, when one looks at it, in fact, that what was trying to be addressed was a concern about the structure of the shareholding, not the situs of the shares, or indeed the certificates. I can't develop that in this. This is supposed to be an introduction, but I will come on to that if I need to. But can I go back? I know it is easy to digress, but I think the court gave indications, I think, to my learned friend that they agreed provisionally that, for example, the worldwide freezing order was relevant context for the construction of the undertakings. And as I'll show you tomorrow, I suspect now, the worldwide freezing order had an exception in it that would have allowed the re-domiciliation to take place without there being a breach. You weren't shown that, but that's rather an important piece of the jigsaw.
That's not 7C, that's something else.
No, it's not 7C, my lady, it's something else. 7C itself I've got submissions to make on because it's not quite as straightforward as it appears. And the argument was had before the judge about it. But there is lurking under there quite a lot of material that one hasn't seen. And just so that if you're interested overnight to have a look, the paragraph of the worldwide freezing order that I have in mind is paragraph 9D, supplemental bundle 1, tab 2, page 44, which allowed Mr Deripaska to execute any transaction with respect to his shareholdings in a sanctioned entity, which included N+, as well as B Finance, which would be which are reasonably necessary to facilitate the lifting of the sanctions. You'll see that the definition of sanctioned entities is in paragraph 17, for example, on page 47. And he was only required to give notice after the event of such a transaction. So if the re-domiciliation had taken place between the granting of the freezing order and the giving of the undertakings, there would have been no arguable breach of the worldwide freezing order. And that is relevant when one comes to look at what the purpose of the undertakings were as context.
But presumably the requirement to give notice is also to give the opportunity to Mr Chernukhin to apply to the court.
No, my lady, because it's only ex post facto notice.
Right.
48 hours after the event, within 48 hours after the transaction.
And so
Within 48 hours of any transaction
Yeah.
being executed.
Yes. So you execute the transaction, and then within 48 hours, you were required to tell the Chernukhin parties that it had happened.
Right, and the transaction with respect to the 45 million odd shares in EN Plus that Mr Deripaska could have executed is what?
Well, what I would say, my lord, is that if the voting of the shares in favour of the continuance was a dealing that was otherwise in breach of the undertakings, that would similarly otherwise have been a transaction that was necessary to, with respect to his shareholding in respect of N+, that was reasonably necessary to facilitate the lifting of the sanction. But so too would the ultimate re-domiciliation have been if it could have taken place within the same window.
But then why did Mr McGregor and Mr Deripaska apologise for not going to the court before the vote in December?
Well, that, my lady, is a separate question, if I may respectfully submit. I'll come on to answer that. But what I'm trying to do at the moment is tell your ladyships and your lordship that there is slightly more context to this than you have presently been shown.
Did the judge deal with the 9D point?
No, my lord.
Why?
Well,
if it's such a straightforward, it's not a breach because it falls within 9D.
It's an answer to it.
Well,
what are we doing here?
well, there are a few little points like that one might have asked the same
It's
thing.
not little point.
Well, it's like the share certificate point, my lord. If the share certificates didn't matter, what are we doing here? You might say.
Are you saying that 9D is the answer to any contempt application?
No, my lord. I'm not saying it's necessarily the answer. I'm saying it's part of an answer as to whether, in fact, you construe the undertakings in the way my learned friend submits you do, and in the way the judge found you do not, and I submit you do not. It's part of it is part of the background to it. And I should say
was
the
it
judge.
drawn to the judge's attention, 9D?
That I can't remember, my lady. I can't remember doing so, and so I assume not, unless I can tell you otherwise. But what he did find, and this was, and partly that was because, the way the case was argued below was rather different in many ways from the way it's been argued here. But that is often the case. Can I just say, though, to make it clear, though, there is a factual finding by the judge just in relation to that point. This is paragraph 61 of the judgment, Court Bundle tab 8, page 111, that the re-domiciliation was, the judge says, a necessary element of the way in which the lifting of US sanctions on N+ was achieved in the event. And so it was a key step taken, he said, to preserve the value of B Finance's shareholdings in N+ for the benefit indirectly of the claimants. So I'd like to go back to where I was, which was the strands the judge had that he pulled together to find the whole case was abusive. The first I've mentioned about knowledge of the re-domiciliation. Secondly was the misleading nature of the evidence, and again, my learned friend challenges some aspects of the judge's factual findings in relation to misleading evidence. This is paragraph 156 of the judgment. But not all of them are challenged, and we'll have to look at those that are and those that aren't in a little detail. But some of them that are challenged, it's not actually the fact finding that's challenged, it's the relevance of the fact, or the supposed relevance of the fact that is challenged. The third thing that judge deals with at 157 is motive. Obviously, that's taken a rather important part of the picture in this appeal. Those, again, are said to be irrelevant rather than challenged as findings of fact. And fourthly is the heavy-handed, aggressive, partisan, and so forth way. And again, those findings aren't challenged per se. What is said by my learned friend is they didn't have to behave any better than that, effectively, as a matter of law.
Well, we've all been around the block in this sort of litigation, but regrettable, I think, that the judge said was that sort of behaviour can be. It is a strong thing, isn't it, to say something is abusive, serious matter to strike out.
Yes, it is.
Something, because of heavy-handed or aggressive behaviour.
Yes, my lady, but that's because that heavy-handed behaviour went way over the line in a case in which a man's liberty was at stake. And that brings this well out of the ordinary run of tit-for-tat commercial litigation in my submission. And it's one of the reasons why, when we look at the question of motive and quasi-prosecutorial approach, the cases do say that when a man's liberty or a woman's liberty is at stake, the court treats it rather differently. And one would hope that it would, with all due respect. And the conclusion that Judge reaches as a result of his findings, my ladies and my lord, at paragraph 163, just bears noting, because the conclusion isn't just that there were those strands that were abusive, but it's that the result was an unfair trial. And I think, as my Lady Justice Asplin said, the ultimate question is one of fairness. And the finding, the conclusion the judge came to after hearing all of the evidence was that the trial of Mr Deripaska would not have been fair. And we submit that was exactly correct. And he goes on to say it might reasonably be thought by an impartial observer not to be fair as well, which is also correct. But there we are. Now, can I then deal with how the abuse argument interplays with the breach grounds? Because it's quite an important point in my respectful submission, and one which my Lady Justice Carr raised early on, as I expected someone to do. And there's a slight, again, this is a slightly, it's an important, if slightly knotty and factual background to this. But I do submit that the court needs to be conscious of how this has arisen and where this is going, if it goes anywhere. The first thing is the judge only decided the question of breach in the context of the civil claim for damages.
Yes.
That's not, I'm not telling you anything new there, obviously, you know that. And he dismissed it because there was no breach and because of the logically prior question that there was no contract. And there's no appeal from the latter finding, and the breach claim, therefore, the civil claim for damages has died a death. Now, he, in my submission, rightly did not regard the question of whether there was in fact any breach as being relevant to the question of abuse. And that was why he was at pains to make sure that he decided the abuse case with an open mind as to the breach case. And you see that he does that expressly at paragraph 104 of the judgment on page 124 to 125.
And was it at your invitation that he proceeded in this way?
No, my lady, it was at his... He came to a provisional view which he put to the parties and which both parties agreed was the appropriate way to deal with.
So did he walked in and he said, I've been thinking carefully about this case, as one would expect of a judge of this hard-working and calibre, and he said, how about we hear abuse first? If I can give a decision at half-time, I will,
yes.
And then we will proceed appropriately in the light of whatever decision I reach.
That's quite a good summary, my lady, but it's a little bit more complicated than that.
Right.
And it matters slightly, I'm afraid, because it is important in my submission to know that Mr Chernukhin's counsel, as he then was, Mr Mill, Queen's Counsel, acceded to the invitation to proceed to deal with abuse without dealing with merits.
But it wasn't Mr Mill's idea, and it wasn't your idea.
It emanated from, in fact, the decision of Mrs Justice Cockrell at the CMC
yes, when
in
she made
February.
these comments about we can deal with it as case management.
Yes,
what have you.
that's right.
Yeah.
So what, can I do with it chronologically so that we get it clear, because it may be important. So at the case management hearing, my client's position was there should be a separate hearing on abuse and then a trial of committal to follow if that failed. My learned friend's approach, Mr Mills, as Mr Chernukhin's leading counsel then was, I think it's fair to say, was rather more in favour of a rolled-up approach, but didn't want the two separating at least. The outcome of Mrs Justice Cockrell's order was that there was a direction for the abuse application to be heard first, with committal to follow, and that it would be a question for the judge whether he heard Miss Berard's evidence in support of the application before he decided the abuse application, or whether he waited and decided the abuse application and then heard her evidence, along with any of the defendant's evidence if it was relevant. Now, what happened then, my lady, is Mr Mill submitted the skeleton that my learned friend mentioned to you, in which he said, it is impossible to decide abuse without deciding merit. And that is paragraph 10 of his skeleton, supplemental bundle, tab 21, page 330. On the basis, he said, the strikeout application was manifestly fact-sensitive. They went in, the judge obviously read the skeletons. Our position at that point, I think, was that the abuse application could be heard without deciding breach. But obviously we accepted, as we always have, that if the breach is strikeoutable on the merits, as it were. That would get rid of it anyway. Now, what then happened, my lady, Mr Justice Andrew Baker sent an email to the parties over the weekend before the hearing, proposing to follow Mrs Justice Cockerell's approach and to deal with abuse first. And that led, can I show you then to an exchange in court about the appropriateness of that approach, separating the two. And you'll see that in the second volume of the supplementary bundle, please, at tab 23, at page 401.
Sorry, bundle 1.
Bundle 2, my lady, supplemental 2, tab 23, page 401. And if you look, please, at page 4 of the transcript, actually, it starts at the bottom of page 3 of the mini-script. Fifthly, the judge says, it was to revert on the same aspect of the plan of action. The parties will have seen an email from my clerk with my provisional view that we should adhere to the process ordered by Mrs Justice Cockerell, albeit I was minded to accede to the suggestion that if we do so, there should be cross-examination of Miss Berard by Mr Pillow before I then hear final argument on the abuse application. And he said that would be efficient and so forth.
But Mrs Justice Cockerell didn't say to deal with breach separately. She simply said, you know, abuse application first.
Yeah.
That's completely open-ended.
Yes.
The question of whether or not breach is part of that.
Well,
Do we actually have what Mrs Justice Cockerell said?
I don't think we do, my lord, in the bundle. So that's another document we will get, and I can read it to you. It simply says the abuse application should be determined at the commencement of the trial, or following the examination of the claimant's witnesses if directed by the trial judge. That was the upshot.
So there's no suggestion by Mrs Justice Cockerell that breach should be hived off, or the merits of the potential merits of the contempt application.
Not expressly, no.
Should be hived off.
Not expressly, no. That's right.
And at page 4 of this transcript, page 401 of the bundle, there's discussion, or there's reference by the judge to abuse and making a no case to answer. Making no case to answer after the cross-examination of Ms Berard.
That's right.
Now, doesn't no case to answer mean no breach?
Potentially, it means no. I suppose it really technically means no contempt. But yes, it includes the question of no breach.
Yeah.
But what I would say, my lady, is that clearly, if it were going to be suggested that the application failed because the merits were so low as to merit a strikeout, then that would have been dealt with at half time.
Yeah.
Well, that would have been a ground to strike out under CPR 18.6.
Ground or indeed to actually make a submission, no case to answer. But that was not the case.
So I think breach, it sounds to me as if breach was floating around in the evidence, but then no submissions made until after the abuse application.
That's almost right, Melody. I think that's fair. What happened on day 2 when we'd had the evidence and we were arguing about?
When you cross-examined, did you not, about whether it was thought that re-domiciliation would affect the undertakings or cause a breach, and why weren't they concerned about it?
On those sorts of issues, yes, I
So
did.
you were cross-examining over the breach issues.
They inevitably covered both the abuse and abuse.
Quite rightly so.
Yeah.
But obviously we had no evidence from the other side on breach, on the defendant's side.
There never was any, even when you moved on to do breach of the civil undertaking. You didn't call any evidence from Mr Deripaska on that either, on the contract claim.
No, but we did call 3 witnesses. Well, we adduced the evidence of 3 witnesses, my lady, that's right. But there was evidence from Mr McGregor and Mr Deripaska that could have been adduced on the committal application had it gone ahead, that wasn't, because there wasn't a committal application, that went into questions of breach.
So the judge had heard cross-examination going over the issues of breach, but no submissions on it. By
Yes.
the time he decided
Yes,
the
that
abuse
I think is a
the
fair.
issue.
Yes.
Is the
Can I just follow that up, my lord, with what I wanted to show you on the transcript, which is at the next tab of the supplementary bundle, page day 2, where the submissions then were being made on abuse. At tab 24, page 492 of the bundle, at page 151 of the transcript, Mr Mill is making his submissions, and it's being said that he's dealing at page 151, you can see, on our fourth ground, which was that there was disproportionality. And he said at line 15, the consequences are very serious. If those consequences constitute a breach, then it is a serious breach, and that can't be disproportionate to be pursuing that. That's the sort of argument that was being made. Obviously, I take on board whether your lordship wants to engage with the question of the merits and whether there is some breach at all, but I am not inviting your lordship to do that. And then he said, your lordship has my submissions on that. I'm not quite sure what that...
Well, that may be him saying, I've told you it's relevant, but you've basically disagreed.
Well,
it depends, you were there, but it's sort of saying, don't worry, you know, I know what you've told me. I'm not inviting you to do what you say you don't want to do. You've heard my piece on it.
Well, I simply don't know what that last part was meaning,
okay.
my lady. But what he was saying was, I'm not inviting your lordship to engage with the merits for the purpose of the abuse argument. That was his express word. And the reason was, if I may venture to suggest, was that it was not... No one was saying these breaches were unarguable as a matter of law or fact. And no one was saying that there was no argument that they hadn't... Sorry, there was no contrary argument to be made that there was no breach. What the judge did, in my submission rightly, at the invitation of the parties as one sees here, or at least the acquiescence of them, was to approach the question of breach on the basis that there was an arguable case that was not there was a real prospect, wasn't strike-outable, but also that he wasn't going to decide one way or another whether there was a breach. He just had an open mind.
But did he make it... Right, did he make... I'm mumbling. The difficulty I have is that I find it very difficult to see how the strength of the case on breach is not relevant to the question of abuse. And to the judge's findings in his oral ruling that I find the motive was to vex and harass, not to bring serious misconduct to the attention of the court. How can you make that evaluative assessment without having reached some sort of view as to the seriousness of the misconduct and the strength of the case at a high level?
Well, my lady, first of all, I'd say this, that it's axiomatic in my submission that an abuse of process argument, if successful, blocks out a potentially successful case. There wouldn't be a need for abuse if it didn't strike out meritorious action.
It's not the fact that there is a strong case does not in any way debar a striking out for abuse, but it is certainly material.
In my submission, it's not material, my lady, unless it illuminates the subjective motivation of the applicant.
Yes, well,
and
the stronger the case, the stronger the likelihood that the motive will not be just to vex and harass.
In my respectful submission, my lady, that doesn't follow as a matter of logic, because one could want to vex and harass, most particularly with a terribly weak case, and one could not care two hoots about the seriousness of the alleged breach if the consequences are zero or negligible, but be motivated completely by animosity and hatred and so forth. And so the judge's approach in my submission was correct to say that as long as the merits weren't so weak as to be strike-outable, as a matter of principle and on the authority, the question is whether the motivation of the applicant was proper or improper. And unless and the judge was able to decide what the motivation of the applicant was in this case, both, as I've said, the fact that it was to vex and harass, if I can put it like that, but also that it was not to bring serious wrongdoing to the attention of the court, without deciding where on the scale of the merits this case lay, as long as they were arguable. And one can see, of course, the consequences of a breach, if established, are objectively ascertainable, and much was made of them. So the judge knew that the competing arguments as to whether the consequences made the the breach if proven serious. But the judge, rightly in my submission, did not descend into the arena of deciding on the merits whether the breach had occurred, precisely because it would have been grossly unfair to Mr Deripaska in circumstances where that very question would arise on any committal trial if the abuse argument failed, or indeed it succeeded and then an appeal succeeded, when Mr Deripaska and his other witnesses were not required to decide whether to give evidence on those subjects. So in my respectful submission, the court should, on an application for committal, only consider the merits of the allegation of contempt if, contrary to my primary submission, they're not relevant at all, assuming they get over the threshold of good arguability. Only, as you say, you have my primary submission. They should not come into it beyond arguability, which no one is suggesting is not present. But if the court wants to go further, there is a real problem of principle in my submission, which is that if the merits factor into the abuse argument, and you were to allow the appeal on the abuse so that a trial were to take place, then there would have to be a trial of the whole question of breach, at which Mr Deripaska's rights were safeguarded, including his right to stay silent or not, but at which all of the evidence that what we would have adduced at that application would be adduced. And I've made the point that there were points like the share certificate evidence that is potentially relevant to construction, for example. But my learned friend, Mr Crowe, in his submissions to the effect that Miss Berard's evidence that there was a procurement of the breach by Mr Deripaska was not gainsaid by Mr McGregor's evidence in his second witness statement. Well, that's another one of these points where, with respect, the trial of that issue has not yet taken place. And you can't decide in the context in which these undertakings were given without the court fairly hearing the evidence that the defendant has to give on those topics. Because the first point on that point was that Mr McGregor's second witness statement was not an answer to Miss Berard's fourth affidavit at all. They were like ships that crossed in the night. But again, that was clear when you understood the chronology. I think the evidence was that Mr McGregor had said that application was substantially finalised before Miss Berard's evidence was served. But more importantly, Mr McGregor's second witness statement wasn't evidence in the committal. So the fact that he says or doesn't say something in the second witness statement was not a matter that was before the judge on a committal hearing.
I mean, maybe strictly that's true, but it's perfectly clear that there was a wholesale denial of contempt.
Yes, my lady.
So with detail and reasons.
Yes.
You know, we did something wrong. We should have come back to court. We apologise. Now I'm going to tell you why there wasn't a contempt. So whether or not it was strictly evidence in the committal, there was evidence on the question of contempt.
Yes, but my lady, what I'm trying to get across, perhaps not as well as I hoped, was that if it's correct, it cannot in my submission be correct that the court deciding an abuse argument should express an opinion on the strength of the merits of the breach point beyond saying that it's arguable and if it's proven that it's serious, none of which is an issue. Perfectly happy to say that, if it matters.
But did the judge proceed on that basis? Because I can't find that.
Well, my lady, yes, he did, because what he knew was that there was no strikeout application. It was accepted that the merits exceeded a strikeout level, and the consequences of a breach, if proven, were objective, and we argued about it.
So where does he include in what everybody agrees is his evaluative assessment for abuse purposes of the fact that this was an arguable claim, which, if correct, meant that there had been serious misconduct?
I can't take your ladyship to that. It's
just
implicit.
so you are aware, my reading of his judgment is that he did not have the merits, did not take the merits of the claim into account at all.
With respect, my lady, he had to take them into account to the extent that they were not being said to be so low that it was demurrable, because that wasn't what we were saying.
Sorry.
Sorry.
But I think that you have the difficulty of how one is to read paragraph 104.
Yeah.
I'm
Did
sorry.
You read the affidavits in defence on breach?
No. But, I mean,
And he didn't have all submissions on breach.
no, and this, my lady, is why. That's an important point. If I may just finish on this. At a trial, at any trial of committal, my client would or may have chosen to give evidence, and so may Mr McGregor, who gave the longest affidavit that set out the most of the factual background in the case. That was not before the judge.
His evidence. What was going to happen if the abuse application failed? What was going to happen on day 3?
Then we would have to turn to a trial, and we would decide who to call. And at some point, of course, Mr Deripaska would have the decision whether to elect to give evidence or not to give evidence.
And that was all going to happen in 4 days, in the remaining 2 days.
Yes, we wanted more time. We didn't get it, but that was how it was planned, my lady. But the really important point, if I may just finish on this, is that if one injects the merits into this process at this stage, beyond saying that it's an arguable case and if proven the consequences are serious, which we don't challenge, then how does that play out in the committal trial were one to follow if you are against me on the abuse case? Because it's not relevant anymore to the damages case, but you'd be making a judgment on breach in circumstances where the trial at which my client, whose liberty would be at stake, hasn't actually happened. And nor did he call and adduce the evidence of Mr McGregor, and that goes into all of the background and the context. So it's not only in my submission wrong in principle on an abuse application to decide anything about the merits except that they're arguable and what the consequences would be if proven factually and legally, which, as I say, I'm not going to seek to persuade you is not arguable, and I'm not going to suggest that consequences, if proven, would not be serious. But beyond that, one is in that very dangerous territory where judges on applications, for example, for permission to commence committal applications are, where it's not for this court to express an opinion when it hasn't heard the evidence that would be before a judge on a trial to which Article 6 applies and the defendant's liberty is at stake.
So it's double. It's double layered. We're not in a position, nor should we, you say, and the judge couldn't take into consideration at the first stage, at the abuse stage, more than you say he did, despite paragraph 104, because that would have been wrong to do so because he wouldn't have had all the evidence.
Yes, exactly that, my lady.
So that's 2 layers.
Yes. And were it otherwise, then the integrity of the process and the fairness to the defendant will be jeopardised.
Thank you, Mr. Pillow. Is that an appropriate moment?
It is, my
I think we have preyed on the court staff perhaps long enough, and I'm very grateful to them. And I think you've probably made up your time.
I think I have, thank you.
So we're now back on track. 10:30 in the morning. Thank you very much.
Thank you.